Good evening, everyone. I am Manya Khanna, a Senior Associate of Operations and Corporate Relations. Welcome you all on behalf of Karuna Mediation and Arbitration Institute and our founder, Mr. Sahil Kapoor. He, being a family dispute resolution practitioner and a mediation enthusiast, founded Karuna Mediation and Arbitration Institute with a vision to spread awareness for mediation for resolving disputes with compassion and empathy. In progress and awareness towards our vision, we used to regularly organize these types of webinars to spread mediation awareness in India for students and professionals who all will be the future building blocks for this particular sector. We also thank Center of Mediation and Conciliation from Bombay Chamber of Commerce for joining us as an associate partner. We have also announced our internationally recognized mediation trainings in collaboration with EMS Solutions, United Kingdom, accredited with IMI and CMC United Kingdom. This training has been done by Ms. Emma McKendry, who is an award-winning mediation trainer. And after a successful completion of this training and assessment, you all will be becoming an IMI qualified mediator. And you can also learn more about these trainings and register yourself for the 5 days starting from 13th of February by visiting our company's website. So in India, construction industry is around 16% of the nation's working population, which depends on constructions on its livelihood especially. And the construction industry is segmented into different sectors like residential, commercial, industrial, and many more sectors. The industry works on a project basis. If a dispute arises, the parties should work together in any ongoing project to resolve disputes as soon as they arise. So, for these, a good construction dispute resolution method should be in place that is efficient but also helps to maintain a good and healthy relationship between a contractor and a client. So, in today's webinar discussion, we will be on how that mediation can be a good resolution method for construction industry disputes. And to impart and share knowledge about today's topic, we have our expert panelists who will throw lights and their insights and experiences to all the facts related to mediation and the construction industry. So, as to how it can be benefited, one can be benefited from mediation in the construction industry. So, we have with us today Mr. Prathamesh D Popat, sir. Mr. Prathamesh is a LEADR accredited and IMI certified mediator and paneled as a mediator with Bombay High Court and other several organizations. He has also practices as a counsel, arbitrator, and a conciliator, and also a basic and advanced mediation trainer, an ADR consultant, an advisor for mediation to parties, and he has also been appointed in so many cases as an arbitrator. We welcome you, sir, on behalf of Karuna Mediation whole team. And
Thank
now
you.
we have Mr. Anil Changaroth, sir. Mr. Anil is a trained accredited mediator and also an arbitrator, dispute board member, and a dispute resolution practitioner, having been in practice since 1995. His practice in Asia Pacific includes under Changaroth Chambers LLC, with a focus on infrastructure and construction with all various sectors, is also an author of the book Resolving Disputes, a guide to appropriate dispute resolution. We welcome you, sir, also. So it's a pleasure to have you all with us. I welcome you all in today's third session of the Saturday series of mediation. Our take from the past mediation session carved our path to the present sessions of mediation and mediation saviors for banking disputes. So construction disputes. Before proceeding further, I request to both of the participants to please switch on their camera so that we can have a visible view and we can have interactive sessions. And if you all, whatever the questions can be asked in the chat box, and in the end, we can put it down with the answers too, with the help of both the speakers. So by the year of 2025, in the Indian construction industry, will become the third largest construction market globally. Till then, why not should we make it up as an effective dispute resolution industry? So my questions are related to this specific construction industry only with the help of mediation. My first question is, what type of issues can come up in what type of issues can come up in construction disputes, and how different are they from other cases? What are the common causes of construction disputes in India or globally? I request Anil sir to please share his views on this first.
Okay, thank you very much. Thank you for for the invitation. If I may start with the second question first, what is the difference between construction and in other cases? Essentially, you must appreciate that ultimately construction disputes are contract disputes, right? So they generally fall within the ambit of contract law, right? It's a subject that you pick up in the first year of law school, and therefore it is applicable to the construction practice as well. I remember in 2004, I did my master's of science in construction law and arbitration, and in one of the first sessions, we had a hour-long discussion on whether or not construction law was a special different area, and we all concluded at the end of the day it's just contract law. So that's the first point. So now the second question you had was, what are the issues that can come up in construction disputes? It's like any other contract, it's a question of breaching of the terms of the contract. And in the construction contracts, it's a little bit far more complicated in the sense that it involves multiple stages, multiple parties, and so on and so forth. So it gets a little bit more complex. But the fundamental issues can be of the quality of the work that you provide, the time that you take to complete the work, the time it leads to issues like whether or not you are entitled to liquidated damages, extension of time provisions, and all that, and the basic defects of the product, the works that are being carried out. In the construction, obviously in construction you've got both patent damage, which is obvious to you, and then latent damage, which is not obvious to the eyes, and it's kind of like embedded in the walls, and it takes a little while before you discover. So you have those issues, and along with those issues, you also have things like performance bond, which are usually required by in the construction industry. Waterproofing, warranties, indemnities, and guarantees all add on to kind of to make the construction issues quite complex, right? But fundamentally, it's all a question of what they breach from the terms of the contract, right? And that's construction aspect. But there's also an aspect of tortious remedies for negligence. So if you have an architect who's designed certain things, and the design is the one that caused the problem, you have also negligence as well. All right. And then you've got the other add-ons like, disruption in the supply chain, employee, the workers and the contractors, supply of workers and all of that. So you've got all of these add-ons, right? I think I'll stop there for now. I know I have not answered the third question, which is what are the common causes of construction disputes in India and globally, but I suppose to some extent I've kind of explained that as well. Right? Thank you for that.
Yeah, I request Professor to please put down his views.
Yeah. So in addition to what Anil explained, from the Indian context now, considering that we have recently got some addition in the Indian law relating to construction matters, where you have construction disputes, you have to look at it from the angle of who is the complainant. And then you get a sense of what are the types of issues that arise. So there are basically two categories. One is the category of the end user, which is the flat owner, flat purchaser, and the other category, which earlier was clubbed with the first one till recently, is the category of the suppliers. Like you have the contractors, the subcontractors. For example, somebody is going to do the ducting, doing the wiring, piping. So they are the subcontractors. Below the subcontractor, below the contractor, below the developer. So all these are one type of disputes, and the other nowadays, which comes under a slightly different additional law, is that of the flat purchasers. In India now, we have RERA. So in Mumbai we have Maharashtra RERA, and in that, should a flat purchaser have any dispute with the seller or the developer or the constructor of the flat that he is purchasing or going to purchase or has entered into a contract with to purchase, then that dispute will go to the RERA tribunal. And over there, you have got two options: either adjudicatory mode or you go through the mediatory, conciliatory mode. If you go through conciliatory mode, you pay 1,000 rupees fees and it comes up before some conciliation officer. They have about 48 of them across the state, but it's all online. So your chances of getting a hearing done is about a month or two. In any case, they have to finish in about 3 months. That's their internal understanding, or they return the file. If you go through the adjudicatory mode, your fees are 5,000. You go and file it for adjudication, and it will come up before either chairman or the first officer over there, the senior officer, and the senior member, and it will be taken for adjudication. But again, it will be sent for first for conciliation. Should you not succeed there, then you come back here. Now, chances of success. Again, I'm sorry to say, if my legal colleagues are here, that if coming through adjudicatory mode, then your chances of success they have found is about 42%, 43% of cases filed for adjudication. If you are going directly for conciliation, then your chances of, I mean, the success rate over there is about nearly double. It's 80, 82%. So you can see where's 42, 43, and where's 80, 82. And the reason is that in conciliation, they do not entertain lawyers. And therefore, the parties get a good settlement, quicker settlement, and more of them get a settlement, 80% people. Of course, it's conciliation, and therefore, like mediation, not much of a difference, that it's your call, party centric, it's voluntary. You don't want to settle, you are free not to settle. The benefit is that in both, whether you go through the adjudicatory mode or the conciliatory mode, or you go through adjudicatory mode, get to conciliation, come back to the adjudicatory mode with a settlement. In any of these, the outcome is the same, that it is binding on the parties and it is executable. So there it doesn't make a difference. But considering that you get a better success rate because you are not having lawyers with you in direct conciliation, and considering that you have to spend only 1,000 rupees, and considering that in a couple of months you can get out of the whole system with or without a settlement, it's always better to go for conciliation. But then the thing is that we consumers would always prefer, like if I am not doing well, I would rely on my family doctor. Then I would go by his advice, which other special. The parties prefer to go to a lawyer, and then they'll go by the lawyer's advice. He would always say, let's first try to adjudicate it. And that's because the lawyers are allowed in the adjudicatory mode to be heard by the tribunal over there. So they prefer doing it that way, even though the success rate is much less. It's just about half. Thank you. And if you are, of course, in the other segment, the first one which I mentioned, where it's a construction dispute between the developer and the contractor, subcontractors, then it's the regular mode of filing suits. Either you have a specific performance or you file a suit, one of the two. That's the basic difference. And that takes about 20, in my court, it takes about 15, 20 years. Elsewhere, things are a bit sooner. That's all.
Thank you, sir, for putting your insights. Now, as both of you discussed regarding the types, issues of in the industry sectors, now my second question is related to that: what legislations governs the adjudication of the construction disputes, and which educating authority takes the matter of the construction disputes? And does the current legislation have any provisions related to mediation or not? So I request Prathamesh sir to have a view on this particular question.
Yes, now we have amended the Civil Procedure Code. Just about every matter that goes to court is sought to be first tried to be mediated. We also have a specific law called the Commercial Courts Act 2015, in which there has been an amendment in 2018 where any matter filed under in that court, if it is above 50 lakhs presently, I am told. Earlier it was about 1 crore or something. Uh, any matter above that threshold limit would first be sought to be mediated, and you have to pay a nominal fee of 1,000 rupees initially, and when both parties follow the procedure of filling up the forms, everything, then you pay whatever would be the fees of the mediators and the whole process, which is, I think, is maximum is 75,000, irrespective of the ceiling, whatever your amount may be. But the ceiling for the total fees is, I think, maximum 75 presently. The rules that are framed for providing this are in challenge in the Supreme Court, but that will take another God knows how many years for it to be heard. So that's where we stand. 75 is the maximum that you need to pay to get through the mediation process. And within 3 months or so, maybe with an additional 2 months, if both parties agree and the mediator also agrees, that they can try to resolve it. And then the matter is back with the legal services, who will then give a certificate to the applicant that yes, since your matter has not been successful in mediation, you can therefore file the suit. So this is what we call pre-litigation mediation, pre-lit. That's for commercial courts matters presently. As I said earlier, the Section 89 is for all matters that are pending and to be filed, where the courts will request parties to consider some or the other mode of the 5 modes mentioned there, which is mediation, conciliation, arbitration, judicial settlement, and lok adalat, which is basically judicial settlement through lok adalat. So you have all these 4, 5 uh, mechanisms. You can choose any one of them. If you don't agree, or even if one says no, or even if both say no, that they don't want to try any, then the court can force them, both of them, to go for mediation. So that's where they usually send them. And there, I think they have about uh, 2 months and additional 1 month should they all agree to extend that period. And it's free, just about free. You have to pay some nominal a few thousand rupees. That's all.
Yeah, basically court mediation is a continuously free going process. I think on a pro bono basis, court is providing some.
Presently, because even the trainings that we give to the lawyers, as I told you, I just finished one training yesterday, 5-day training. They charge the lawyers only 10,000 rupees, and the rest of the amounts are footed by the Bar Council. So naturally, when you're getting your training for free, we expect you to give some free service also, give back to society. But it's not totally free. They do get 2,000, 5,000, 10,000. Sometimes we'll say, I see the stakes are pretty high. Maybe the parties should therefore pay 25,000 per person, which is what sometimes the judges do. Sometimes they leave it to the parties. You directly negotiate with the mediator, so that my fees at in those days were 15,000 per hour. Now it's 25,000 per hour, provided it's just 1 or 2 hours. It's if it's much more than, it's not just 25 into 5 or 10. It's much more than that. But basically, that's how the things stand in the court annex scenario, where either the judge will decide or the parties can negotiate with the mediator. All the system says 2,000 or 5,000, whatever it be. The legal services department will get the parties to pay to the mediator. That's the court annex system.
Thank you, sir. Anil, sir, your please use.
Okay, so your question is actually a interesting question, because you've actually asked two very distinct questions. One is about adjudication and the other is about mediation, and you have to first fundamentally appreciate that they are both very different. Right? Let me explain why. They all fall within the regime of what I call appropriate dispute resolution. I don't call it alternate dispute resolution. I haven't called it alternate for almost 10 years now. The reason I do that is because maybe about 10 years ago, litigation and arbitration were the primary way of resolving a disputes. Right? Both of those are adjudicative, meaning it's a third party that makes a decision. Right? Now, over the last 10 years, there have been so many different methods of dispute resolution that have come aboard that you now would look at it as what is the most appropriate under your circumstances. So, on the one hand, you have conciliation, negotiation, and mediation, which is purely something within the parties' hands to control and decide, right? And I call that consensual to some extent. Whereas everything else is adjudicative, meaning things like neutral evaluation, expert determination, dispute boards, conflict avoidance board, adjudication, arbitration, and litigation are all adjudicative methods of dispute resolution. All right, so that distinction you have to appreciate right from the start. And many practitioners still 10 years, 15 years into practice, and they cannot make the distinction. So now, coming back then to your first question on adjudication, let me just describe what adjudication is to construction industry. Now, just before I do that, one sentence I'd like to make is that if you are out in America, everything is adjudication, whether in criminal court, whether in civil court, whether in bankruptcy court, they're all adjudicated matters because somebody else decides. So if you are coming from America, practicing in America, when you use the word adjudicate, it refers to everything. It's like litigate or going to court, right? So just keep that in the back of your mind. But in most other jurisdictions, when you use the word adjudication, it primarily relates to construction disputes. Okay, so in England, Australia, New Zealand, Malaysia, Singapore, we all have statutory adjudication. What it means is that the parliament passes a legislation that allows construction disputes to be decided by way of adjudication, a fast-track method of dispute resolution. Okay, so all over the world, when you say adjudication and you're talking about the construction industry, you're specifically talking about these countries. England started it, then Australia had it, New Zealand had it, and then Singapore has it, and then Malaysia has it, Ireland has it, and a few other countries are all looking at it. Now, this regime, of course, you can have adjudication, contractual adjudication, meaning in the contract you set it out that you want your dispute resolved by way of adjudication. But in all of the countries that I've given you examples of, adjudication is a statutory regime, meaning passed by parliament. And what it does is this, because it's adjudication, it's a fast-track method of dispute resolution, there are certain requirements, timelines, specifications of what you must file, and so on and so forth. It's found in the Act. If you comply with those specific technical details, then you can commence you resolve your dispute by way of an adjudication, and it's settled within a very short time frame, 2 or 3 months. I say 2 or 3 months because you take into Singapore, it's a shorter period. In Malaysia, it's a longer period under the Acts. Now, all of this is in Singapore, it's administered by the Singapore Mediation Center. So that talks about your second question, because you said which adjudicating authority takes the matters and deals with it. So in Singapore, if you decide you've done your paperwork, you put in your payment claim or in time, the other party has filed the payment response in time, and so on and so forth, you can go by way of adjudication. You commence it through the Singapore Mediation Center, and that's the authority that deals with it. In Malaysia, the authority that deals with it is the Asia International Arbitration Center, right? That deals with adjudication matters, right? And then it goes through a process. So that's adjudication. To answer your question, most of when you talk about adjudication, it relates primarily to construction industry. 2, it's primarily statutory based. That means passed by parliament. 3 is that it's very fast, short turnaround. A lot of people call it rough justice. As long as a claimant shows that they made the work was done, substantiated, and made a payment claim, they would be entitled to your money. Now, if the responding party or the losing party is not satisfied with it, they'll wait till the end of the project before they commence arbitration, and so on and so forth. Okay, so that's the first 2 part of your question. The third part of your question is that does the current legislation have provisions for mediation? When you say current legislation, I hope you're not meaning the adjudication legislation. No, you got to keep it distinct. Now, if you talk about generally whether legislation for mediation is available, yes. In Singapore, I'll give you an example. I've been practicing for 27 years and I've been practicing mediation for that long a time. The reason for that is in our rules of court at the state court, which is less than 250,000 US dollars, all matters at one stage in the court proceedings will go for mediation. So it's legislated to some extent, meaning it's in the rules of court. So when you commence your proceedings in court, you have your statement of claim, you have your defense, you have your pleadings at end, you start to exchange documents. At that point in time, you go into mediation. So commercial matters in the state court, which is up to 200,000 US dollars, 90% of the commercial matters go to mediation, and of the 90%, almost 80% succeed in mediation. Okay, in the high court, what happens is this: while it's not in the rules of court or legislated for them to go to mediation, there are these practice directions that are issued, and in the practice directions, parties would be asked, "Have you considered mediation? Are you going to consider mediation?" and so on and so forth. And then you end up, trying to go to mediation as well. Now, most of the high court matters, whenever it does go to mediation, it goes to the Singapore Mediation Center or the Singapore International Mediation Center. So they are the institutes that administer mediation. In the state court, in the court system itself, there's a chambers where there are about 4 or 5 judges who specifically only do mediation, and they don't sit as trial judges. They don't cross over. So if you're a mediating judge for the 3 years you're there mediating, you do not deal with court trials and all that. So that's basically it. I think maybe just one quick point to add is the fact about the Singapore Convention. I don't know whether we will have a chance to talk about it, but let's see. We'll talk about that. That's all I have to say at this point in time at the moment. Thank you.
Yeah, thank you. So all what I got it that in basically in Singapore, whatever the authorities have the point of mediation in construction disputes. Plus, I think so. It's not compulsory one. What I got is that, right, sir?
Sorry, what do you mean? What is not compulsory?
Like the person should meet up directly in the compulsory mediation process.
Okay. So it's that's a yes and no, because primarily, if you understand what mediation is, it's a consensual thing that parties decide themselves if they want to. All right. But because I said in the state court, the rules of court provides that you must, right? Of course, at the end of the day, the parties can decide if you don't want to, right? But generally, parties will attempt mediation, and in certain matters, especially in the high court, there could be, at the end of the day, adverse inference taken against the party that it did not allow for mediation to go in terms of cost, right? So that there are those things in place. All right. So to answer your question specifically, it's not compulsory, but there's a mediation act in place. There's this mediation convention in place. The rules provide for mediation. So generally, a lot of people do go into mediation. All right. So just keep that in mind.
Yeah. So, like Bill sir also in Ireland has said the statutory duty on lawyers before issuing the proceedings on behalf of client to advise them about the benefits and advantages of mediation. I must say is the good step from the government side also. So, in regards to that only, my third question is, do you think mediation is well suited to handle the construction disputes compared to other traditional methods and routes? And when should mediation be used in the construction disputes? So, what are your views on compulsory mediation before opting to start a litigation? I request Prathamesh sir to please insight us on this point.
As I said, for home buyers, they do have this tribunal which has the jurisdiction to take up construction matters. That's a RERA. And you have the option of going directly for conciliation, which is the same as mediation. In India, we have got the Arbitration and Conciliation Act of 1996, which not only is everything as is in mediation, but there is an additional benefit. Since inception, since 1995, when it was a bill and later on became an act in 96, we are the first country to have what we call executory provision for conciliated settlements, what we call MSA nowadays, mediated settlement agreements. If you do it through conciliation under the 96 Act, then you get a finality which is binding and executable. That is the benefit that RERA is offering to those who come before it for settlement of their disputes. And therefore, parties should be going for conciliation directly. But as I said, they take advice of lawyers, and lawyers say, no, let's try adjudication. And little do the parties know that even through adjudication, they would again be landing up before the conciliation officer. And because it is through adjudication, the success rate is not so great, and they get only about 42% success rate. But yes, it is said to be compulsory, and therefore they do send it to the conciliation officer. So it is compulsory in that sense. As for the other type of disputes with the subcontractors, contractors, they being commercial matters, they would usually be above 50 lakh rupees for such construction disputes, and therefore they would also be required to go through mandatory mediation at the pre-litigation stage. However, the act though has been framed with teeth, the following rules for these for running this provision under the Commercial Courts Act, which came in place in 2018. Those rules have taken the teeth away from the law that has been brought in place by this amendment. So what is happening is that parties are told that, well, it is something which both parties should pay the amount, then only will the mediation start. So as we say, ke tali do haath se bachti hai, you can't clap with one hand. So if the other party does not play ball and does not pay the fee, then mediation doesn't start. Then of course this applicant will get a certificate saying that, well, the other party didn't respond to your mediation call or mandatory mediation, therefore we certify that you can file this in court. So it is mandatory but still optional under the present rules as they stand. Supreme Court has said, when the rules have been challenged before the courts, the Supreme Court has said that this is like one step forward, 20 steps backwards. But then they'll have to sit and delve on that and adjudicate on that too, which God knows when that will happen. This statement was made about 3 years back in 2018 when the rules were challenged. So let's see what happens.
Let's hand over to Anil sir. Yes, sir.
Okay. So on your first question was whether or not mediation is well suited to handle construction disputes, right? Now, again, you got to look at fundamentally what mediation is about. All right. If you appreciate that mediation is where parties are guided to come to a resolution that is satisfactory to them, where parties are encouraged to move from their positions to what is of interest to the parties, and at the end of the day, then you'll appreciate that mediation can work in almost any type of dispute, right? So it's not necessarily privy to just a certain type of disputes, and on that basis, yes, most definitely, mediation is suited for construction industry disputes, and in fact, it's to some extent slightly more suited to construction industry disputes because you have contractors, you have developers, and all those kind of things, and people like that often want to stay in a good relationship and they want to carry on working because there are some subcontractors who are specialist contractors, and you'll eventually want to come back to them. Right? I'll give you a quick example. About 8 years ago, I was in Sri Lanka, and I had seen a developer, and he was telling me how he was going about to start an arbitration with another major developer, and he asked me what should I consider. Then I told him consider mediation. So I explained to him what mediation was, and then he asked me, so how much would it cost? I said maybe if you get an international mediator like me or whatever, it might cost $8,000 to $10,000 per day. And then he had this shocked look on his face, like, oh man, all hell is going to break loose. And then he softly asked me, he said, so how long would it take? In a very scared and fearful manner, thinking about that $10,000. I said, a day or two. And he said, what? And his eyes lit up and he said, what do you mean? I said, in a day or two, we'll settle the matter. Right? And then he says, oh, I seriously need to think about it. 2 years later, when I saw him back in Sri Lanka, He said, sir, what to do? We are in arbitration and it's gone on, and the only happy people are the lawyers, and we've got nowhere. And it keeps going on. So in that sense, mediation is most definitely workable in the construction industry, right? As opposed to a traditional adjudication and litigation. Yes, remember I explained the difference between one is consensual, the parties get to decide, whereas in adjudication or litigation, it's a third party that decides, and one party will definitely not be happy about it at the end of the day. So going down the path of mediation is a no-brainer, right? And sir here who practices mediation will tell you that as many mediation matters you settle as soon as possible, you can go on to the next and the next and the next, instead of dealing with one client in litigation for 1 year, 2 years, 3 years, right? At the end of the day, you leave a very bad aftertaste for the client, right? Because either he gets all of what he wants or he doesn't get all of what he wants, right? We are happy with the money we make, but the clients will never be happy. So going down the path of mediation is really quite straightforward. The next part of your question was, should mediation be used in construction dispute? Obviously, like I mentioned. What are your views on compulsory mediation? Now, that's a trick question. Again, sir here will tell you that fundamentally, when you talk about mediation, it's about parties coming to a decision that they want to do that, right? So this word compulsory becomes very, very tricky, right? In our rules in court and some of the legislation we have, that you must go by way of mediation. So the real advocates of mediation will stand up and say, how dare you force me into a corner, right? And they can argue that. So you might have that concern, right? But the flip side is that with everything that's in place, the Singapore Convention on Enforcement of International Mediated Settlements and all of that, you find more and more contracts putting provisions for mediation, right? Now, there was a time when it used to be multi-tiered dispute resolution clauses, where you start with conciliation, negotiations, and you move up. And if those fail, and then you come to mediation and arbitration and so on. But the world again has changed. For example, 12 years ago, I worked with the Singapore Institute of Architects in their minor works contract for projects that were between 200,000 to about 4 million or 20 million Sing dollars, which is about 15 million US dollars, are called minor works contract. And in there, we have mediation, expert determination, and arbitration all on the same platform, not in the multi-tier way. So parties can actually decide which of those methods they want to approach. Okay. So, I mean, that's a topic of its own, multi-tier and then dispute resolution mechanisms and how it functions. That's a whole new different area to talk about. But this is where I'll stop as well. Thank you.
Yeah, thank you. So I must say that mediation is well suited for construction disputes too, and must be a savior for both the contractors, parties, and all one who are involved into that. So my next question is, role of courts is settling the disputes related to the construction, and are the parties willing to resolve the matters through the mediation? And what are the reasons behind the lack of practices or awareness in India, especially in India, and we can share the globally news to also in the construction industry only? So I request, yes, Anil sir, please, any views related to the Indian sector also, please, you may share.
So I start off with the court's role, right? You find the world has changed so much, especially coming out of the COVID-19 pandemic, right? Everybody's been put in the same position. Everybody has got the same problems and the same issues. And you find the world is turning towards better methods of resolving disputes and so on and so forth. So courts have, like in Singapore, obviously, because in the state court, it's in the rules of court. In the high court, there are practice directions that encourage parties to go to mediation, right? So at every stage, as Sir had mentioned that, Bill had mentioned that in Ireland, they have your mandatory requirements. We in Singapore as well. So for example, in my letter of engagement, I can tell you straight off, paragraph 6 tells you my scope of my engagement with you is to advise you on ABCD, but also on dispute resolution mechanisms. And I'm supposed to periodically remind you of those things. And I've got an annexure, which is about 2 pages long, summarizing each of those dispute resolution mechanisms. And I constantly share that with them. Now in court, what happens is, interestingly, a couple of years ago, I was in-house, and we had a matter where the courts had sent parties to us to try and mediate. The reason for that was that the court was going through a trial of the matter. The parties in a construction matter had about 15, 20 issues. heads of claims, right? And when the break of the trial came about, for about a month's break, when there were other matters the court had to deal with, the court said, on these 5 items, we've dealt with 5 items. There's another 15 items to go, but on these 5 items, would you like to consider going to mediation? They came to us. We mediated those and settled those 5 items. That encouraged their parties to settle another couple of more items. And by the time they went back to court, they only had the remaining 4 or 5 items left. Right? So you get that. And courts would encourage parties throughout the process, sometimes even on the, in the state court. I think about 40% of my matters that have gone to trial, the first day of the trial, the judge actually would encourage, they cannot force, but they will ask you to consider the logic of trying to settle. And I have had maybe 20% of my matters that have gone to trial. On the trial dates, we have settled up, right? So, the court guiding people and moving people towards that is acceptable. Now, then the second question is about in India, right? Now, with India and with every other place, I must state this, and I'll state this with conviction, because I've been trained in investor state mediation. I've been trained in commercial mediation. I've been trained in family mediation, and I do international mediation. In fact, we're at the moment now, I'm just finalizing an arrangement to fly to Brunei to settle 3 matters, 2 accident matters and a family matters between obviously 6 parties and all of those kind of things. Training in mediation is absolutely critical. And the right form of training is absolutely important. Sir mentioned that he's training people across India and getting certified. I'm sorry to say this. I know I'm being recorded, but I'll say this. On LinkedIn, you find plenty of people who tell you that they're mediators and arbitrators, right? They're not trained.
And trainers.
And they're not trained. They're not qualified. They're not trained. If you take a look at my LinkedIn, you'd see that I've also done restorative justice and emotional quotient. These are all things to develop to become better mediators. But I'm telling you, at least half of the people who are out there and profess to be mediators and all that are not trained. So, sir,
You're being generous.
Yeah.
And you're being generous when you say only half.
Yeah. And what sir is doing with the Bar Council of India and getting people trained is absolutely critical. All right. Because you cannot just become a mediator and expect to you must have the mannerism, disposition, the foresight and understanding to be a mediator. And it's a really tricky business, right? As much as arbitration, you need to be trained in award writing and so on and so forth. Mediation also is not just a snap of a finger and you can be a mediator, right? So if India is going to take the path, you really need to get trained right. IMI and all of that is very, very important. Of course, you will see that I'm not on the IMI list, but that's because I haven't had the time to fill up the forms and all of that. But I've been trained with CEDA. CEDA is an international organization, Center for Effective Dispute Resolution on investor state mediation, on their professional mediation and all that, because I get trained in all that, And so that is absolutely critical. If you want to go down the path of mediation, please make sure you got proper training. And what sir is doing with the Bar Council or the Bars Association, I'm not sure whether it's the Bar.
The Bar Council of Maharashtra and Goa.
Yeah.
We have a National Bar Council of India, and then the State Bar Council of Maharashtra and Goa also.
Exactly. And just to highlight, in Malaysia there's an Asia Institute of Alternate Dispute Resolution, and I'm the deputy chair of the professional development. I've been working with their committee for over 4 months. They've just got approval from IMI to do the mediation training, and I'll be leading the mediation training for that institute.
Yeah,
right?
Yes, sir.
Yeah.
Even Karuna Mediation, our institute is also providing the same training, and we are only focused to provided that specific training which is into the mutual mediation. Yes,
exactly.
and that too is an IMI certified CMC1 and by the specified trainer only.
Yes, and then 40 hours, and it has to have a role play and a whole lot of things, and all of that is important. Just sitting for lectures and watching people talk about mediation doesn't, and getting a certificate attendance doesn't get you anywhere near being qualified, right? So I'll stop there as well for now.
And yes, my next question is related to the mediation bill only. Even with the mediation bill and enactment of the mediation bill, we must say that there can be a change of the landscape of the construction disputes even through the mediation. So in India and in globally also. So what are you both expecting from something from the mediation law in respect to the construction industry?
May I,
Prathamesh,
Anil?
yes,
Yes,
Prathamesh,
please.
please.
So, my expectations now are pretty much streamlined because we already have the bill in front of us. The bill is giving us three benefits. Benefit number one is that the mediator is going to be given 6 months. If both parties and the mediator agree, maybe another 6 months to mediate it properly. And that's important because in India, we are never in a hurry. I don't, people keep joking, why do we need a bullet train for the Indian psyche? Where do we want to get in a hurry? But that's a good thing because if your courts are going to take 20 years, I don't mind giving you 6 months to settle it properly and wholesale full in a wholesome way. The second benefit is that the limitation stops. So that 6 months that you spend in mediation, your limitation clock is not ticking. And the third benefit is that at the end, whatever be the outcome, should you have a mediated settlement agreement, then that will have a finality, bindingness, and enforceability. So that's the benefit where today people are forced to do all this through a sham arbitration, which you file and then through that go to conciliation, through that get a settlement, come back to the arbitrator and get an award on agreed terms under section 30 subsection 4 of the Arbitration Act that these people have mediated. And that's a roundabout way. Or you file a litigation knowing full well that we have already settled the matter, but we want some finality in a binding way, so which is enforceable. So then they do that way. But all that will be obviated, and people can and will be able to mediate directly and privately and get the benefit of execution should it be required. People keep harping about asking questions. Even in my last day, we spent 1.5 hours just on this point. Okay, but what is the benefit in private mediation if you can't enforce it? I said, we don't need enforcement. I want this red shirt. I was wearing something else. I chose to change it. I'm not going to again change it in the middle of the show. If parties have entered into an agreement and they are now reneging from it, it's because they only saw the rosy side. They didn't see the thorns in the relationship. Now, when they have seen the thorns and are settling, it's a very robust, wholesome settlement that they have, knowing full well and having accounted for all the thorns that are in the path. Now, what they do will be a robust one. And having gone through the mediation process properly, Anil, pardon me, some people are listening. Uh, Mr. Bill Holohan is there, but I find that in the English countries, it's more the Englishman's house is his castle. So it's more of a shuttle diplomacy happening. Whereas in Australia, US, and in Singapore also, and India also, we are more into joint sessions. So parties are seeing that happening. They are getting trained into that. They are getting into that trademark style of conversation, and therefore they also hone their skills. That tomorrow down the line, if there is some dispute in the mediated settlement agreement, they would work it out themselves, not come back crying to mediator that what happened or go for another mediation. So when we do facilitative style and fully in the joint sessions as much as possible, then the parties also get ingrained into that modicum of conversations, and therefore they settle the matters even later on should they have a dispute in that agreement. So I find good training by the mediator will amount to good uh, training to the participants also. And once that participant comes, then he would get his things sorted out without coming back to the mediation room, at least sway that other party.
Yeah, thank you. So, Anil sir, yes, please, your
Okay,
views.
so I'm all of what Sir has just mentioned is absolutely correct, and I'd like to take the last point about the enforceability. Now, with mediation and some of the other dispute resolution mechanism, people have this concern of whether it's binding, right? And they all ask that question. Half of them, because they're not legally trained, they have no idea. The ones who are legally trained just automatically think that is an issue. The answer is very simple. If you settle a matter, you sign an agreement, It's binding. If
Yes.
one party defaults on that agreement, then you sue on that agreement and not the whole dispute anymore. Just that. So it's a very simple exercise, right? So that's point number one. That anything, whether it's neutral evaluation, whether it's a negotiation, as long as you sign off, right, it's binding. Okay, so that's point number one. Point number two is exactly what Sir said. While I've canvassed this point about the Singapore Convention, the Singapore Convention is on allowing you to enforce on an internationally settled dispute through mediation. But the question is this: why do you need to enforce when parties have moved away from their position to their interests and they themselves decided, exactly like Sir said, his red shirt? Why would he? He's come in happy. He's very happy about wearing his red shirt. Why does he then, just to irritate the other party, just decide, no, I'm not going to wear my red shirt? No, it's not going to happen because they've settled, right? So to some extent, the need for the Singapore Convention is questionable, right? To some extent, but because of the Singapore Convention and what mediation has become, people are starting to look at it as a real, tangible method of dispute resolution. So in that sense, the new Singapore Convention has an effect on people. When some people in some jurisdictions have decided that they want to go to mediation just to avoid litigation and drag out the matter and never settle. All these things that are put in place, whether it's the Singapore Convention, whether it's your Mediation Act, whether your rules of court have put mediation in place, all helps to crystallize mediation as a formidable dispute resolution mechanism. That's it.
Thank you, sir, for putting your wisdom. As we are very time constrained, so I will be reaching down to the as soon as possible to the next question. My next question is that do you think that private institutes who are providing the mediation can help the court to reduce the burden of construction litigations pending in courts? Yes, Anil, so please.
Yes, definitely. But they better be good institutes. They better have international recognitions. They better have international training and all of that. They better have a set of rules in place, which is not rocket science. You just go and Google, mediation rules. You find so many. It's so easy. I say that with a little bit of a frustration because, even to this day, you find arbitration clauses to resolve the dispute by arbitration that is horrendous. And I don't know why people can come up with horrendous clauses in the agreement when you can take 2 seconds to Google and you find it, right? So private institutions they must have a good scheme of pricing, good fallback positions, a clear set of rules, and it will definitely help the industry as a whole.
Any suggestions regarding to this dispute that how should they should lend up into that with the mediation to private institutions? Anil, sorry.
Well, I think what you guys are doing, canvassing yourself and putting up these talks and promoting, will get people recognizing. If it's a private institute that's going to get to help in the construction industry, you go at construction talks. You do exactly how you reached out to me. It's because of my LinkedIn and what I've been doing. Right, that private institute needs to get out there. It needs to get the recognition internationally. It needs to get qualification internationally. It needs to have a proper set of rules. It needs to have a whole clear framework. Recognize people on the panel, and really putting people on the panel is not about politics. It's about putting the right people on the panel to get the job done. That's it. All right. That's it.
Thank you.
I'll go a step further on that path of frustration. That not only do we bypass mediation and directly put arbitration, but we put ad hoc arbitration. Probably in your world, you have no more heard of it in the last 10 years, but we have ad hoc arbitration. So our arbitrators take 4, 5, 6, 7 years and they keep, and I'll give you one example that there was a panel of 3 arbitrators and one of the junior arbitrators told the presiding arbitrator, shall we request them to increase our fees because we have agreed to these fees about 3 years back. And that presiding arbitrator immediately doubled the fees and directed that the doubled fees shall be paid before the next hearing. And nobody bothered to ask the question that why the hell did you take 3 years? It should have been 3 months. Who is responsible for this delay? And in institution arbitration, 3 months is what you finish it.
Yes.
Otherwise, you don't get up arbitration. And
Yep.
that's the charm of institution arbitration. And here we don't even bother with that. We just put ad hoc. And that's because the lawyers put it. And that's because the more it runs, we lawyers benefit. We mean because I'm also a lawyer. So if I'm wearing that hat, then I benefit by taking my clients through that ad hoc arbitration route. But mediation, as you rightly said, is the future. And that's why we are pushing it. And that's why the bar is also in my state taking great efforts to get people trained. And I see a great benefit because today, even in the Commercial Courts Act, our minimum is 3 lakh rupees. But we have kept it only for matters above 50 lakhs because we don't have so many trained mediators who are proficient in this job. So first we want people trained, then we want them to get some experience, and then we'll reduce the threshold limit to something lower like 25 or 10, then finally at 3 whenever we can. Thank you, Manya.
Yeah, thank you, sir. Sir, any views on the private institutions of yours regarding to the service provided?
Private institutions are actually, there are a handful of them who are doing great work. Today in Mumbai, we have got a couple of 3 or 4 or good ones. One is this CMC, who is the sponsor of this show, this event. Then we have got CMA, that is Center for Mediation and Arbitration. We have IAC, that is IMC, International ADR Center. And now these, the difference between the three is that CMC is only into mediation, conciliation. CMA is into mediation and arbitration. IAC is also into mediation and arbitration. And there is a fourth one, AMP, which is again only into mediation, that is Association of Mediation Practitioners. And they are doing great work. They are connected to the court, so they keep getting matters every now and then from the court system. And they've got a very nice success rate, considering that it's a nascent organization, very just come up just 2 or 3 years back, quite green in that sense, I would say. But they're doing great work. And considering that the court keeps calling them up to take up more and more matters, okay, we got 10 more for you, we got 12 more for you. Can you take 8 more along with the 10 we just said? So that shows that they are happy with what we are doing compared to maybe what others are not doing. So I find a great benefit to the society from these private institutions, more so because these private institutions are focused on mediation. And some of them who are focused only on mediation and have nothing to do with arbitration, they will hone their members' skills in mediation to the extent that they keep giving them refresher add-on courses. So these members get better and better because they also get net practice from the court system, and then they come for refresher courses with their queries. So it's a win-win situation for everybody. Thank you, Manya.
Thank you, sir. So my last and foremost question for this particular session is, can you please share your views about organizing such webinars, and does it help the society to get aware about the mediation? Anil sir, please.
Yes, most definitely. And I think you alluded to this in the start, in a structured fashion, that you have an introduction to it, and then you develop a series. So, if you do a series of 6 or 7 over 4 months and then repeat that, educating people is a starting point, right? But they must appreciate that just being educated doesn't necessarily make you qualified and trained. That's a different aspect. So you develop all of that. And so, the world has changed so much that webinars and all of that, I speak almost every other week all over the world now at the moment. And it's very easy to engage and keep in touch and all of that. So yes, most definitely, I think these programs are really helpful and relevant. Thank you.
Yeah, thank you so
I
much.
couldn't agree less with what Anilji said. Yes, what really is important is to take the word to the masses. We have a saying in Hindi, "Jungle mein mor nacha kisne dekha." If a peacock danced in the forest, who saw it? Though, however magnificent a dance it was. So you need to get that peacock to dance in the marketplace. You need to get mediation services out there in the open. You need to advertise them. Unfortunately, in India, at least we lawyers are so pathetic at self-advertisement and self-propagation and all that. It is looked down upon. That's why we don't do it. But mediation services can certainly be marketed and advertised, and that's what the legal services department of the several high courts are doing. They are holding roadshows. They are having those Chauraha program where at the crossroads they take their people and make them do a drama so that people passing by can see what's happening. And earlier we had a major hassle when the one group did it in front of our High Court. Quite a few lawyers, 50 of them, gathered around this group and said, "You better wind up and get lost, otherwise we'll beat you up." And they had to leave. But today, the legal services, which sits in the same High Court building, is themselves doing it. So it's very difficult to dislodge them from their mission. So that's a good thing. And I hope that down the line we'll be a little bit more open about advertising them in the open. Like we have people sitting in the buses idle for 2 hours that they travel. Same about the trains. We have got TVs in both the trains and the buses. Why can't we advertise them? We have got that O Media or Zoom Media doing that. Well, they keep advertising that if you need to advertise, we are the people to contact. So I think someone needs to contact them. But please put in our slide also. And of course, we have got the legal services also coming out with nice videos. Anilji, you can go on YouTube and look for the video by Nalsar, Nalsar. And just Google Nalsar and you'll find there 2.5 minutes. It is in Hindi, but I'm sure they have some subtitles over there to get a sense of what they are trying to say. But it's a good thing. The message being that now the courts are coming to your house, to your crossroads. You need not walk all the way to the courts. And that we are going to do through mediation also. So we'll bring the mediation system to your place. You don't need to travel all the way to the city. So that's the message. So I'm glad that this program also is online, and therefore people from several parts of the globe are able to access it, and hopefully you will put it up for viewing through YouTube also. And such programs are definitely required, as many as possible. It's whatever is there is too less in my view, and you must bring more and more people, get different stakeholders to give their experiences. I may have said something rosy about the RERA, but if you get some end users who have gone through the process, they might have some heroic experiences, or they might something even better. Or even if they say the same thing, coming from the horse's mouth has greater value. That yes, I've taken my dispute through the system and it worked fantastic. So you should get these stakeholders also. That would add charm to your program and even different perspective to it. Thank you.
Thank you, sir. I must say that I am very much obliged from both of you, your presence and your wisdom on this particular topic. So I request participants, if you have any questions, then please one by one you can ask. Yes, anyone? And I request everyone to please fill the feedback form also, which is already provided in the chat box, so that it will be helpful for us to conduct more such webinars and related to mediation. Yes, Mr. Gulshan, sir.
My name is Gulshan Chawla. I'm a mediator at Delhi High Court Samadhan. So it is always a pleasure to hear Mr. Anil Changaroth, wherever he is, whichever forum he is, he's an internationally known mediator and arbitrator. So it's always a pleasure, and the insightful session which he has given today, that's so wonderful. And we are so grateful to Mr. Popat, who is training so many mediators like us. We are in Delhi and Mr. Popat is in Mumbai. It's so nice of you. And so far as this training is concerned, Mr. Anil Changaroth, we have taken training from Samadhan, where all High Court and Supreme Court judges come, and they impart training. And training is so intense that, after when you enter the training room, it's in Manesar. If you have been to that place, it's in Manesar Heritage. So it's a so rigorous training. Once I wish that if you are in India, please attend that training and you would love that. Maybe that we would request Delhi High Court Mediation Center to invite Mr. Popat also for some training. Because till now,
I've come to Samadhan at least. I've come to Samadhan.
I've been there as well. Veena is a good friend.
Yeah, we have taken training from Mr. Niranjan Bhatt and Mr. Shriram Panchu.
Yes.
Okay.
So,
Yes.
Yes.
we took training in 2011. It's so wonderful. From 2011 to 2022, we have traveled.
Yeah.
So it's
Thank
so
you.
wonderful session. Thank you very much for this insightful session. Thank you, Karuna, so for hosting this program. So we hope they would keep on doing it in future.
Thank you. Thank you. And I've visited that more than once. Every time I'm in Delhi, I usually go to the High Court to visit
Yeah,
it.
whenever, because from every evening I'm there, I'm conducting most of the mediation in Samadhan,
Yeah.
and I might have settled more than 100 cases
Brilliant.
in
Brilliant.
Samadhan. So we have taken training, we have taken sessions from people like you. It's
Yeah.
a wonderful journey. Here. Thank
Thank
you very
you. Thank you.
Thank you, sir. Thank you for joining us. So I must say that whatever has been asked, I believe the audience has the better insights about the concept of mediation and the construction industry. And on behalf of the Karuna Mediation team, I would like to thanks to all the panelists for sparing their valuable time and sharing their valuable insights and thoughts and experience too with this particular large number of period of experience in this particular industry. And I must also appreciate to all the participants for their participation and asking up their query. And wishing you a very happy good day ahead. Thank you for joining us soon, and we will be
Thank
back
you.
soon with another series.
Thank you very much.
So
And thank you, Bill from Ireland as well.
Yeah,
Brilliant. Thanks a lot, sir.
Yeah, thank you so much. I
Okay.
hope that everyone had filled the feedback form.
Good night.
Yeah. Thank you,
See you.
sir. Good
Bye.
night. Good evening. Bye, sir. Have a good day. Namaste.